Hello and welcome to LLB 345 Internet Law. As always, I'm Patrick Johnson. Today I'll be talking to you about the 2012 Victorian Supreme Court case of Trkulja. Honestly, I'm not at all sure how to pronounce the plaintiff names, so for the purpose of this video, I'm going to refer to him as Mr. T. Anyways, as I was saying, the case of Mr. T and Google Incorporated and Google Australia Proprietary Limited. Now the facts of the case are as follows. When you searched Mr. T's name in Google, it would come up with images of Mr. T displayed with other images of known criminals such as Tony Mockbell and Dennis Tanner. Now underneath all of these images, it would actually also display Mr. T's name underneath them. The search also brought up an article on a website that chronicled the events of the Melbourne criminal underworld, with an article about Mr. T being shot by a hitman, which actually did happen, if you were wondering. The Melbourne crime site also showed 9 photos of people who had either been accused of or found guilty of serious criminal offences. The combination of these things gave rise to the defamatory imputation that Mr. T was so involved with crime in Melbourne that his rivals had actually hired a hitman to murder him. After Mr. T became aware of these materials, his lawyer wrote a letter to Google notifying of the defamatory nature of the search results and demanding that they remove them. Well, it seems that Google didn't do it quick enough, so Mr. T brought an action in defamation. The American arm of Google, Google Incorporated, argued that they were merely a passive platform that was not capable of being a publisher of the defamatory material. They also raised the innocent dissemination defense pursuant to Section 32 of the Defamation Act. However, they were not successful, and there were 2 reasons why Justice Beach found that Google was a publisher of the defamatory material. The first reason was related to intention. Although Google didn't have the specific intention to defame Mr. T, the court decided that Google intended to publish the material. This is because the search page was produced as a result of the Google search engine, working as the programmers had intended it to. That is, a search term is entered, and results show up. Secondly, after being notified of the defamatory material by Mr. T's lawyers sending the letter, Google did not take any action to remove it. The court viewed this fact as giving rise to the inference that Google consented to the publication of the material. In his reasoning, Justice Beach compared Google Incorporated to newsagents that may sell a newspaper containing a defamatory article. In the case of these newsagents, they are often able to use the innocent dissemination defense to avoid liability. However, Google could not rely on this defense. The fact that they had been notified of the defamatory search results showed that either they had known or ought to have known that they were defamatory. Alternatively, Google's lack of knowledge was likely due to their negligence. His Honour also noted that Google would have been able to rely on the innocent dissemination defense for a reasonable time after receiving notification that the material was in fact defamatory. Now you may be thinking, so what can we take from this case? Even online, not removing or amending defamatory matter that is under your control will amount to publication for the purposes of defamation action. Had Google removed the defamatory material within a reasonable time of being notified of its existence, they would have been protected by the innocent dissemination defense and not been held liable as a publisher of defamatory information. Personally, I feel that the requirement of notification in internet cases such as these is one that is pretty fair, due to the fact that there is too much content for companies to constantly be on the lookout for any material that is defamatory at all. Thanks for watching my video. I hope it's helped you understand the case of Mr. T and Google a bit better. Bye.